Welcome back to the deep dive. Today, we are wading into some truly murky legal waters.
We are.
We're looking at that line between, being a good neighbor and having a legal gun to your head, forcing you to act. We're talking about the bystander problem.
It's one of the most counterintuitive areas of tort law, for
Mhm.
sure. It really confronts a basic human question.
Yeah.
If you see something terrible about to happen, do you have a legal obligation to stop it?
Exactly. And let's just set the stage with the scenario. Let's say you're at a bar. A stranger walks up to you, points to a woman across the room, and says, "I'm going to go over there and shoot her."
Okay.
Then he starts walking toward her. "You've got a cell phone. You could yell. You could do something. But you do nothing." He shoots her. Are you liable?
Under the general common law rule, no,
Yeah.
you are not liable. You can sit there, finish your drink, and watch it happen.
That is just wild. I think most people listening would assume you'd be in handcuffs.
Oh, absolutely.
Yeah.
Morally, you might be a monster. But legally, this is the classic distinction between what we call misfeasance and nonfeasance.
Yeah.
Misfeasance is when you actively create a risk.
Yeah.
You drive drunk, you swing a bat. Nonfeasance is just doing nothing. And the general rule is no duty to act. You are not your brother's keeper.
But, and there's always a but on this show, that rule has some serious holes in it.
Massive ones.
Yeah.
And that is our mission today. We are going to dissect Module 6, Duty to Control and Protect. We're going to figure out exactly when the law flips that switch and forces someone to intervene.
All right. So map out the path for us. How are we going to break this all down?
We're going to follow a really specific analytical path. First, we'll look at the duty to control. This is all about the defendant's relationship with the aggressor. We'll hit the Tarasoff doctrine.
Okay.
Second, we pivot to the duty to protect. Now we're focusing on the relationship with the victim. Think landlords, businesses.
Yeah.
Third, we have to look at the government, the public duty doctrine, and police liability. And finally, we end with the all-time classic, the scope of duty and the foreseeable plaintiff with Paul's graph.
Okay, let's unpack this. Let's start with that first one, duty to control. Like you said, generally I don't have to control a stranger. But what if I'm not a stranger? What if I'm, say, a professional, and I know my patient is a ticking time bomb?
That is the exception. The general rule is no duty to control a third person to prevent harm unless a special relationship exists.
Yeah.
And the most famous and definitely most controversial application of this is in mental health.
Which brings us to the case that changed everything. Tarasoff v. Regents of University of California. Let's analyze Tarasoff. First up, what are the legally dispositive facts here?
It's just a tragic set of facts. You have a patient, Prosenjit Pilar, at UC Berkeley's counseling center. He becomes obsessed with a woman, Tatiana Tarasoff.
Okay.
And during therapy, he explicitly tells his psychologist that he intends to kill Tatiana when she gets back from a trip to Brazil.
So he says it outright.
Outright. And the therapist took it seriously. He actually had campus police detain Padar, but they let him go. And here's the critical failure. The therapist never warned Tatiana, and he never warned her parents. Padar later went to her house and killed her.
Just a horrific failure. So looking at the lawsuit from her parents, what was the core legal issue?
The issue was this. Does a psychotherapist who knows or should know that a patient is a serious danger to someone else owe a duty of reasonable care to protect that potential victim?
And what rule of law did the court apply here? Could you state the full black letter rule and break it down into its testable elements for us?
Absolutely. The court created what we now all call the Tarasoff duty.
Yep.
The rule is a therapist has a duty to use reasonable care to protect the intended victim. And this rule really breaks down into three key elements.
Okay.
First, a special relationship, which here is the therapist-patient relationship. Second, foreseeability, an assessment that the patient poses a serious danger. And third, an identifiable victim.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, the special relationship?
Right, so this was the bridge the court had to build. Generally, you have no duty to control a third-party potter in this case. But the court reasoned that the therapist-patient relationship is a recognized special relationship.
How did they make that leap?
They analogized it to doctors who diagnose contagious diseases. If a doctor knows a patient has, say, smallpox, they have a duty to warn people who might get infected. They just applied that same logic to a danger of violence.
Understood. Now, what about that second element, foreseeability, and how did they balance that against the huge policy issue of patient confidentiality?
This was the absolute heart of the fight. The defense argued, if therapists have to tattle on their patients, no one will ever seek therapy. The whole system relies on trust.
Of course.
But the court did a balancing test. They held that while privacy is incredibly important, public safety is paramount. And they gave us that famous quote, "The protected privilege ends where the public peril begins."
Wow.
So because the therapist actually predicted the violence, that foreseeability of harm just outweighed the interest in keeping it secret.
And on the third element, the identifiable victim. How'd that play out here?
Well, in this case, it was crystal clear. Podar named Tatiana. She wasn't just some random member of the public. She was the specific named target. So the duty attached directly to her.
So after analyzing all those elements, what was the court's final conclusion?
The court held that the therapist could be held liable for the failure to warn or protect Tatiana Tarasov. The case was allowed to go forward.
Okay, so that rule seems pretty clear for therapists, but let's push this. Let's make it harder and, honestly, a lot grosser to test the limits of this duty to control in a domestic setting.
I think I know where you're going with this.
Yeah, I'm thinking of that New Jersey case, JSV-RTH. Let's set up a hypo based on those facts. You have a wife. She knows, has actual knowledge, her husband is a pedophile. She's leaving town for a business trip. She knows that neighborhood kids are probably going to come over to use their swimming pool while she's gone. She says nothing. She leaves. And the husband abuses the neighbor's children. My question is, does the wife have a duty to warn the neighbors about her own husband?
It is a visceral hypo, but it perfectly illustrates the concept. And the court in JSV-RTH said yes, she does.
Why, though? I mean, spousal privilege is a really strong legal concept.
It is, but the court basically ran through the same elements. The key here was what they called particularized foreseeability. She didn't just suspect he was creepy.
Right.
She had actual knowledge of his specific dangerous propensity. And she knew specific children were coming into a zone of danger that she controlled, her pool. The court found that the duty to protect those children just overrode the policy of spousal confidentiality.
So it's the knowledge plus the proximity that creates the duty.
Exactly. If she just thought he was weird or if the victims were random strangers, the result could have been totally different. It was the specific knowledge of a specific threat that mattered.
Okay, let's pivot. We've talked about controlling the bad guy. Now let's talk about the duty to protect the victim. This is usually where businesses and landlords come in.
Right. Now we're looking at the relationship between the defendant and the plaintiff. And the general rule here is that a business or a landlord usually has no duty to protect patrons or tenants from crimes by third parties.
Unless
Unless there is a special relationship like an innkeeper and a guest, or a landlord and a tenant and D, the crime was foreseeable.
Let's test this with the landmark case. Klein v. 1500 Massachusetts Avis Apartment Corps. So let's analyze Klein. First, what are the legally dispositive facts?
Okay, so Ms. Klein was a tenant in a big apartment building in D.C. When she first moved in, security was tight. They had a doorman, a desk clerk, the whole 9 yards.
Right.
But over the years, the landlord just let it all go. The doorman disappeared, side doors were left unlocked. At the same time, crimes in the hallways started going up, assaults, robberies. The landlord knew all about it but did nothing. And sure enough, Mrs. Klein was eventually assaulted and robbed in a common hallway.
So what was the core legal issue for the court?
The issue was, does a landlord owe a duty of care to protect tenants from foreseeable criminal attacks by third parties in the common areas of the building?
And what rule of law did the court apply? What's the rule and its elements?
The court basically established that a landlord must take reasonable steps to protect tenants from foreseeable crime in those common areas. And the rule really has 2 key elements.
Okay.
Element 1 is control. The defendant has to have exclusive control of the area. And element 2 is notice or foreseeability. The defendant has to know about the danger.
Thank you. Now for the court's elemental analysis. Let's walk through this. How did the court apply that first element, control?
Yeah, this is the key. The court reasoned that an individual tenant, like Mrs. Klein, she has no power to police the lobby or the hallways. She can lock her own apartment door, but she can't secure the front gate.
She's ceded that control to the landlord.
Exactly. She's given that power to the landlord. So the court held that because the landlord has that exclusive power, the duty follows that control.
Understood. Now, what about the second element, notice and foreseeability?
The facts here were just damning for the landlord. There was a documented history of assaults right there in the building. The landlord had actual notice. The court pointed to these prior similar incidents and said they made the harm to Ms. Klein totally foreseeable. It wasn't some random event. It was a pattern they ignored.
And after analyzing all the elements, what was the court's final conclusion?
Judgment for Klein. The landlord was liable, specifically for failing to maintain the same level of security that was in place when she first moved in.
So if my landlord has to protect me, surely the police have to protect me, right? I mean, I pay taxes. Their motto is literally to protect and serve.
You would think so. But this is where we run into the public duty doctrine, and this is where a lot of people might get frustrated with the law.
Let's get into it. What's the general rule for the police?
The public duty doctrine states, a duty owed to the general public is a duty owed to no one individually.
That sounds like a riddle.
It basically means you cannot sue the police for failing to stop a crime unless they made a specific promise to you and you relied on it.
We have to look at the case that proves this rule, and it is a heartbreaker. Riss v. City of New York. Let's analyze Riss. First, what are the facts?
It's just devastating. A woman, Linda Riss, was being terrorized for months by a man she had rejected. He threatened to kill her, threatened to scar her. She went to the police over and over again. She showed them the threats. She begged for protection. The police did nothing.
And then...
The suitor hired a thug to throw lye acid in her face. She was blinded and permanently scarred.
Unbelievable. And she sued the city. What was the core legal issue?
The question was, is a city liable for negligence when its police force fails to provide protection to a specific person who asks for it because of a known threat?
And what rule of law did the court apply?
They applied the public duty doctrine, straight up. The rule is that, absent some specific law, a city is not liable for failing to provide police protection to any one individual. The two big ideas they leaned on were, one, the distinction between a general duty and a special duty, and two, this policy idea of resource allocation.
Okay, let's do the elemental analysis. How did the court apply that first part, the whole general versus special duty idea?
The court basically said that police protect the public as an abstract concept. They don't sign a contract with every citizen to stop every crime. So they held Linda Riss was just a member of the public. Asking for help didn't create a special relationship.
That feels so harsh given what she told them. How did they justify this under that second idea, resource allocation?
This is the big policy argument. The court said that if they allowed this lawsuit, the courts would end up telling the police how to do their jobs, deciding where to send officers, how to use limited cars and time. That's a job for the mayor or the legislature, not for a judge. If every crime victim could sue because the police didn't get there in time, the city would go bankrupt, and the courts would effectively be running the police department.
And after that analysis, what was the court's final conclusion?
No liability. Linda Riss lost her case.
That's a tough pill to swallow. Is there ever an exception to this? Does the law ever pierce that immunity?
Yes, but the bar is incredibly high. We see the exception in a case called Sorochetti v. City of New York.
How is Sorochetti different?
In Sorochetti, you had two key things that were different from Riss. First, there was a court-issued protective order. That's a judge officially saying this person is dangerous. Second, the police gave specific assurances. They told the mother, don't worry, we'll handle this.
Ah, so that combination, the order and the promise, is what matters.
Exactly. The court held that the protective order plus the specific promise created reliance. The mother stopped worrying and looking on her own because she was relying on what the police said they would do. That created the special relationship that was missing in Riss.
So no promise, no duty.
For the most part, yes.
Okay, so we have one final piece of this puzzle. We've talked about duty to control, duty to protect, the police, but we still need to define who even counts as a victim in the first place.
Right. This brings us to the ultimate law school debate. Duty to the world versus duty to the foreseeable victim.
And the case that every law student knows by heart. Palsgraf v. Long Island Railroad. Let's analyze Palsgraf. First, what are the facts?
It's like a Rube Goldberg machine of a tragedy. Mrs. Palsgraf is standing on a train platform. Far away, at the other end, two railroad guards are helping a man get onto a moving train. They kind of shove him aboard.
Okay.
In the process, the man drops a package he's carrying. It's wrapped in newspaper, so no one knows what's inside. Turns out it's fireworks. The package hits the rails, it explodes, and the shock wave from the explosion knocks over some heavy scales at the other end of the platform, and the scales fall and hit Mrs. Palsgraf.
Wow. So the guards were negligent toward the man with the package, but they ended up hurting Mrs. Palsgraf. What was the core legal issue?
The issue was, does the railroad owe a duty of care to a plaintiff who is standing completely outside the foreseeable zone of danger created by their actions?
And what rule of law did Justice Cardozo apply? What's the rule and its key element?
Cardozo's famous rule is that negligence is not actionable in the air. He said duty has to be relational. The key element is the zone of danger, or what we call the foreseeability of the plaintiff.
Thank you. So for the elemental analysis, how did Cardozo apply that zone of danger element to these facts?
Cardozo argued that the risk is what defines the duty. The guard's action shoving the man created a risk to him and his property. Maybe the package had a vase in it and it would break.
Right.
But there was absolutely nothing to suggest that the package would explode and hurt someone 30 feet away. So relative to Mrs. Palsgraf, the conduct wasn't negligent at all because she was outside the orbit of danger. She was not a foreseeable plaintiff.
And so what was the final conclusion?
Complaint dismissed. The court found no duty was owed to Mrs. Palsgraf.
But there was a famous dissent in that case, right? From Judge Andrews. What was his take on it?
Yeah, Andrews argued for a duty to the world. He basically said if you act negligently at all, you are liable to anyone who gets hurt, period. He didn't care about the zone of danger. For him, the only limit should be proximate cause. Is the result just too bizarre or too remote from the action?
But he lost.
He lost. Cardozo's foreseeable plaintiff rule became the law of the land for duty.
Okay, we have covered a massive amount of ground. We've gone from psychotherapists to landlords to police to exploding fireworks.
You certainly have.
So let's bring it all together. What does this mean for the listener? If they're in an exam room or just trying to spot these issues, how do they attack this?
Okay, here's your exam attack plan. When you see a fact pattern where someone got hurt and a bystander is being sued, run this checklist.
Okay.
Step 1 is classification. Ask yourself, is the conduct misfeasance or nonfeasance? Did they create the risk? Duty is probably easy. Did they just fail to act? Okay, now you start hunting for exceptions. Step 2 is special relationships. If it's nonfeasance, does a relationship exist? If it's defendant to threat, like in Tarasov, you're analyzing duty to control. If it's defendant to victim, like in Klein, you're analyzing duty to protect.
Got it.
Step 3 is the foreseeability check. For a Tarasov situation, is the victim identifiable? For a landlord situation, were there prior similar incidents? Did they have notice?
Makes sense.
Step 4 is the public entity check. If the defendant is the police, stop. Apply the public duty doctrine. Unless you have that specific promise plus reliance, like in Soroketti, the plaintiff loses.
And finally,
Step 5 is the Palsgraf limit. Even if a duty seems to exist, always ask, is the plaintiff inside the zone of danger? If they're a freak accident victim way down the platform, Cardozo says no duty.
that is a powerful framework. It really does turn a mess of cases into a logical flowchart.
That's the goal. The law is always trying to balance that moral desire we have to help people with a practical reality that we can't be legally responsible for everything that happens everywhere.
It certainly does. And it leaves us with a pretty provocative thought. We started with the moral question of the bystander. The law says you don't have to act. But, as we saw with Tarasov and JS, the moment you know something specific, the moment you have special knowledge, the law just might drag you off the sidelines and into the game, whether you like it or not.
Knowledge is power. But in tort law, knowledge can also be liability.
Something to think about the next time you overhear a conversation you wish you hadn't. That's it for this deep dive. We'll see you next time.